Welcome everyone, I am Ritika and joining me are Adimesh and Shruti. Today, we delve into a fascinating case that highlights the intersection of technology and contract law.
Hello everyone, looking forward to discussing this intriguing case with you and our listeners.
It's always interesting when the legal system grapples with evolving technology.
So let's begin by discussing our case in question today. Recently, the Canadian court in Southwest Terminal versus Achter Land and Cattle made a landmark decision regarding the use of emojis in establishing contractual consensus. The court held that the use of the thumbs up emoji demonstrated consensus ad idem, indicating the acceptance of a contract. Now, before we discuss this case in more detail, Adimesh, is there an Indian parallel to this?
Well, not a strict parallel, but there is a recent instance worth mentioning. In and around January 2019, the Bombay High Court, by way of its judgment in the matter of SBI Cards and Payment Services Private Limited versus Rohitas Jadhav, recognized serving a court document in the form of a PDF via WhatsApp as a valid service of notice under the Civil Procedure Code, which is the applicable Indian statute on civil procedure. This step does reflect the increasing integration of technology into the legal proceedings in India.
In fact, with businesses adapting to the digital age, especially through platforms like WhatsApp and Instagram, it becomes crucial to understand legal implications of such technological shifts.
So let's understand the Southwest Terminal case. The court in Southwest Terminal had to determine the validity of a contract between Southwest Terminal and Achter for the delivery of 87 metric tons of flags in November 2021 at a specified price. In order to determine this, the court had to determine, first, whether there was consensus ad idem between the parties, and second, whether the signature requirement under the Canadian Sales of Goods Act was met.
Yes, and it's also important to discuss what all the court considered to establish consensus ad idem between the parties. The court considered past contractual dealings between the parties. Here, the parties had entered into about 15 to 20 similar contracts. The parties would negotiate the quantity and price either in person or over a telephonic call, following which the seller would ask the buyer to draft the contract. The buyer would send a picture of the contract to the seller over WhatsApp with a message asking the seller to confirm the terms of the contract. The seller would then reply with okay, a fine, looks good, and then parties would perform the contract.
The court in this case also analyzed the meaning of the thumbs up emoji. It relied on a website, dictionary.com, which defined the thumbs up emoji as an expression of assent, approval, or encouragement. The seller argued that the thumbs up emoji merely indicated receipt and not acceptance. But the court considered the circumstances and the parties' established practice and held that the thumbs up emoji symbolized approval of the contract.
Now, moving on to the signature requirement, the Canadian Sales of Goods Act mandates a written and signed note for authenticity. The court determined that the thumbs up emoji originating from a specific representative of the seller with a unique cell phone number met the signature requirement.
Thanks, Ritika. Now let's discuss the broader implications of this case. In the proceedings, the seller raised a public policy argument, suggesting that interpreting the thumbs up emoji as acceptance could open the floodgates to similar cases involving various emojis. In response, the court observed that it cannot and should not attempt to stem the tide of technology and common usage, as technology is the new reality in society. But it is also important to dwell a little more on the public policy argument. In our day-to-day life, emojis might not be deliberately used to convey the exact meaning that they are ideally or conventionally meant to convey. Unlike words, phrases, or maxims, there is no authoritative source for the meaning of each and every emoji that is available to use. In fact, even the court in this case found itself at a lack of authoritative sources to understand the ordinary meaning of the thumbs up emoji. So in my opinion, courts must tread with caution in attributing legally binding obligations to every new tool that technology might spring upon us.
You're right, Adimesh. But we must also understand that this is not to say that in cases such as the present one, where a certain practice of entering into contracts had already been developed between the parties, here they could not take the defense of the public policy argument. This case must be viewed as a call of caution for businesses. While in isolated or one-off instances, it may be argued that the intention behind using a thumbs up emoji was to acknowledge the receipt of a contract or of any other document, such an argument cannot be taken where a practice has already been established, as in this case. As we discussed earlier, here there was a clear practice of the buyer sending the contract with a message seeking confirmation, and the seller responding very briefly and thereafter performing the contract.
Yes, it's crucial for businesses to introspect and understand the established practices when dealing with contracts through digital means. This case serves as a reminder for businesses to stay mindful of their communication practices, especially in the digital realm.
That's right. Well, that wraps up our discussion on the judgment of the Canadian court on the interpretation of the thumbs up emoji. Thank you everyone for tuning in.
Thank you.